My name is Sierra Sanderson, and I'm an attorney with MNK Law. At MNK Law, we are more than just your attorney. Our mission is to listen, understand, solve, and execute challenges you face by being your business advisor as well. One of the common documents that companies execute with third parties are non-disclosure agreements, commonly referred to as NDAs or confidentiality agreements. Nearly all businesses have valuable confidential information, and protection of the same is at the top of most businesses' priorities. Confidential information can be shared, received, and exchanged with customers, suppliers, and other parties in the ordinary course of business, and in a wide variety of commercial transactions. As a result, it is incredibly important to create binding confidentiality obligations to help protect the parties that disclose information in these circumstances. There are specialized types of confidentiality agreements for different types of situations, such as mergers and acquisitions, financial transactions, and joint ventures. However, in this video, we will discuss confidentiality agreements more generally, and will identify 4 clauses that you should take extra care in reviewing. However, before we start discussing specific clauses, it is important you identify the type of confidentiality agreement you are executing. Specifically, is this agreement going to be unilateral or mutual? With a unilateral confidentiality agreement, the non-disclosure obligations will apply only to the party that is the recipient of confidential information. Conversely, with a mutual confidentiality agreement, each party is considered as both a disclosure of its own confidential information and a recipient of the other party's confidential information. In these circumstances, both parties are subject to identical non-disclosure obligations. Here are 4 items that you should pay close attention to when you're reviewing your confidentiality agreements. First, the definition of confidential information and what is excluded. Second, any use and access restrictions. 3, any safekeeping and security requirements. And lastly, the agreement's term and the survival of non-disclosure obligations. Okay, let's get into it. First, it seems obvious, but how do you define what should be considered confidential information? It's critical. While you want this clause to be broad enough to ensure all of the information a business or its affiliates may disclose is covered, you still need to ensure that there is enough specificity that the agreement isn't later deemed unenforceable. Because if it's too broad, that's likely to occur. When defining confidential information, you'll usually see employee and contractor lists and records, business and marketing plans, financial budgets, projections, blueprints, designs, and drawings. It's important to customize this definition to encompass confidential information that is critical to your business specifically. Now, conversely, it is just as important for the parties to identify what is not confidential information, such as when information becomes public knowledge other than through the fault of the other party. For what is not confidential information, we also recommend editing this section to require documented proof. Anyone can claim that they had information prior, but added documented proof bolsters your protection if you are the disclosing party. Next, use and access restrictions. It is important to identify who specifically has access to the confidential information and limiting the purpose under which it can be used. Is it only going to be accessed by upper management or any employee within the company? Furthermore, when restricting access and using confidential information, it can be helpful to define the business purpose for executing the confidentiality agreement and limiting the use and restricting the same to executing for that specific purpose only. Third, depending on the type of circumstance and confidential information that is being disclosed, the parties may want to identify and align on what safekeeping requirements are expected to be implemented. For example, recipients of confidential information may be required to implement specific physical and network security methods and procedures to safeguard the disclosure's confidential information. Lastly, the term of the agreement and the survival obligations of non-disclosure are vital to ascertain. For the term of the agreement, confidentiality agreements can run indefinitely, covering the parties' disclosures of confidential information at any time, or they can terminate on a triggering event. Whether or not the overall agreement has a definite term, the parties' non-disclosure obligations can be stated to continue for a certain amount of time, running for some number of years from the date of which information is actually disclosed. Now, typically, a survival period within a confidentiality agreement is between 1 to 5 years. Here's an example. Let's say you have a term for 2 years from the start of the agreement and no survival obligations. Further, that there are no other more comprehensive agreements and the 2 years has now lapsed. Let's say you continue working with the other party. You are vulnerable. But how? With no survival obligations included in your agreement, following that 2-year period, the confidentiality agreement is now no longer operative and any information disclosed is not protected. If you're the disclosure to safeguard your information in your business, you can set a time period, generally between 2 years and 5 years, following termination of the relationship between the parties, wherein the non-disclosure obligations will continue. If you are the disclosing party, this offers greater protection. Within the survival period, be sure to carve out trade secrets exceptions that must be kept confidential per any federal and state codes or law, for as long as it is a trade secret. Of course, there is a lot more to confidentiality agreements than what we have briefly discussed and highlighted today. However, the 4 areas we covered today are a great starting point to review within your own confidentiality agreements. If you have any questions or require our assistance drafting a confidentiality agreement, visit our website at mnklawyers.com or email us at info@mnklawyers.com. Thank you for watching.